Warm greetings everyone. I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. Today, we will learn about the bars to matrimonial reliefs under personal laws. Dear learners, we shall discuss the following segments in today's lecture. Firstly, introduction, bars to matrimonial reliefs under Hindu law, bars to matrimonial reliefs under Muslim law, the Indian Divorce Act 1869, provisions under the Parsi and the Marriage and Divorce Act 1936, provisions under Special Marriage Act 1954, and finally the conclusion. Let's begin our discussion with a brief prologue to the topic. Under most of the present laws, marriage is a contractual relationship. In cases of violation of the matrimonial rights and liabilities laid down under various personal laws, the aggrieved party is entitled to file for various matrimonial remedies under a given law. These matrimonial reliefs are remedies available to the aggrieved party to address the violation of his or her matrimonial rights. The Hindu Marriage Act 1955 and the Special Marriage Act 1954 are perhaps the two most important pieces of legislation governing marriage and divorce in India. Section 9 to 13 of the Hindu Marriage Act and Section 22 to 27 of the Special Marriage Act talk about certain matrimonial remedies. For example, if a spouse treats his or her spouse with cruelty, the aggrieved spouse is entitled to various matrimonial reliefs like maintenance, separate residence, or divorce. However, where a law provides for these reliefs, there are certain bars to claiming them. In the present module, we will discuss the bars to matrimonial reliefs under various personal laws. Dear viewers, we will discuss bars to matrimonial reliefs under Hindu law. The remedies mentioned in the Hindu Marriage Act 1955 have certain bars that must be crossed in order to get matrimonial relief. These bars are based on the doctrine of equity. This doctrine states that one who comes to equity must come with clean hands. This means that the person seeking matrimonial relief must prove the fault of the other party and also cross the bar to matrimonial relief. This maxim examines the past conduct of the aggrieved party and ensures that he or she does not take advantage of his or her wrong. The bars to matrimonial relief have been defined under Section 23 of the Hindu Marriage Act 1955. The provision states that if the aggrieved party is seeking relief in contravention of any of the bars mentioned in clauses A to E of the Section 23 Clause 1 of the Hindu Marriage Act, then such grant for relief shall be quashed. Before any relief is granted by the court to the petitioner, he or she must prove the fault of the respondent and make sure that there are no bars to such relief. Any order passed by the court against these bars will be null and void. The bars to matrimonial reliefs are as follows. Firstly, taking advantage of one's own wrong accessory, connivance, condonation, consent obtained by force, fraud or undue influence, collusion, delay, and any other legal grounds. These bars are explained in detail as follows. Firstly, taking advantage of one's own wrong. These bars on matrimonial relief are based on the doctrine of equity, which means one who comes to equity must come with clean hands. In every petition for any matrimonial relief, the burden of proof is on the petitioner. He or she has to prove that relief is not sought to take advantage of his or her own wrongdoing. Further, to succeed, a petition must be bona fide, and if filed with an ulterior motive, it cannot succeed. For example, if a petitioner has been constantly cruel to his wife, which has resulted in her desertion. Later, the husband files for divorce under Section 13 of the Hindu Marriage Act on the ground of desertion by wife. Then such relief cannot be granted to the petitioner, because the petitioner was responsible for driving out his wife. The court will not grant him any relief, as he is not allowed to take advantage of his own wrongs. Second bar is accessory. Section 23 Clause 1 Clause B mentions the term accessory. This concept is mainly used in criminal cases. Accessory means participating in a criminal or immoral act. Hence, if the petitioner is in any small way involved in or helping the respondent in an immoral or criminal act, matrimonial relief shall not be granted. The petitioner shall be an accomplice to the crime. This bar applies only to adultery under the Hindu Marriage Act. In simple words, if the husband has helped the wife commit adultery, he cannot file a petition for divorce on the ground of adultery committed by the wife, as he has been an accessory to the adulterous act of the wife. Third bar is connivance. Connivance, like accessory, is involvement in an immoral or wrongful act. In accessory, the petitioner is guilty of helping the respondent commit the crime, whereas in connivance, the petitioner encourages the wrongful act of the respondent. Connivance is anticipatory, willing consent given by the petitioner to a wrongful act. In such a case, the petitioner will not be eligible for relief. Further, the basic distinction between accessory and connivance is, in accessory, the petitioner is as guilty as the respondent owing to his or her involvement, but there is no involvement of the petitioner in the case of connivance. Further, in its essence, connivance precedes the matrimonial offence. For example, spying on the spouse to confirm his or her suspicion doesn't amount to connivance. Next bar is condonation. Condonation is the forgiveness of the crime committed by the other party. Hence, while granting relief, the court has to examine whether the act committed by the respondent in the case of cruelty or adultery is not condoned or erased by the petitioner. It is assumed that once the act is condoned, the offender will not repeat it. The two main ingredients of condonation are forgiveness and reinstatement. If the petitioner has condoned the act of the respondent spouse, he or she will be barred from seeking matrimonial relief on the condoned ground. In Chandra versus Avinash, 1967, the Supreme Court held that the resumption of cohabitation and marital intercourse after full knowledge of the respondent's adultery may amount to condonation. A singular act of intercourse would not amount to an indisputable presumption of condonation. Further, in Dastane versus Dastane, the husband petitioned for divorce on the grounds of wife's cruelty. It was established that after the alleged acts of cruelty, parties continued cohabitation, and during that period, a daughter was born to them. The court observed that normally sexual intercourse is evidence of both forgiveness and reconciliation and raises a presumption of condonation. However, there can be revival of a condoned offence. In the court of law, it is believed that once acts are condoned, there is no going back. However, there is an obvious condition that the spouse will not repeat such an offence ever again, commit any other matrimonial offence, or be involved in any of the matrimonial misconduct. If he or she breaks such a promise, then the condoned offence will revive. Next bar is consent obtained by force, fraud, and undue influence. When a divorce is sought on the ground of mutual consent, such consent shall not be obtained by force, fraud, or undue influence. If it is proved that the consent was obtained by force, fraud, or undue influence, the decree of divorce by mutual consent obtained will be quashed. Next ground is collusion. Section 23, Clause 1, Subclause C of the Hindu Marriage Act mentions the bar of collusion. Collusion is an absolute bar under the Hindu Marriage Act as well as the Special Marriage Act. Collusion is an agreement between the parties to obtain matrimonial relief by deceiving or misrepresenting the court, or by producing false evidence. The only exception to this bar is divorce by mutual consent. The burden of proving to court that there is no collusion on the part of the spouses rests with the petitioner. The Hindu Marriage Act has abolished this bar in cases where marriages are null and void, but it is available under the Special Marriage Act. Next bar is delay. Unnecessary delays are a bar to matrimonial reliefs under the Hindu Marriage Act 1955. Likewise, the burden of proving that the delay was not intentional falls on the petitioner. This bar is based on the doctrine of laches, which states that in a civil dispute, a party may not be allowed to file a suit due to an unreasonable delay. There can be other legal grounds. Section 23, Clause 1, Subclause E states that matrimonial relief shall not be granted if there is any other legal ground restricting matrimonial relief. Thus, this is a residuary bar. There is a process of reconciliation also under that. Section 23, Clause 2 imposes a duty on the court to make an attempt to bring about reconciliation between the parties. The reconciliation shall not be applicable in instances where divorce is on the grounds of leprosy, conversion, insanity, venereal diseases, renunciation, or presumption of death. Here, it is important to note the observation of Law Commission of India regarding the irretrievable breakdown of marriage as a bar to matrimonial relief. The Law Commission, in its 71st report in the year 1980, examined the existing grounds of divorce under Hindu law and recommended the introduction of a new ground, that is, irretrievable breakdown of a marriage, stating that either of the spouses can file a petition for dissolution of marriage on the ground that the marriage has broken down irretrievably. The Commission further recommended the bar to this ground of divorce, which is, if the wife is party against whom the petition for dissolution of marriage on the ground of irretrievable breakdown of marriage is filed, then she can claim the bar against it on the ground that the dissolution of marriage will result in financial hardships and struggles. Further, if a grant opposing the decree for dissolution of marriage is filed, it is the duty of the court to examine the facts and circumstances of this, the interest of both the parties and the interest of the children, if any. If the court finds that the dissolution of marriage will result in financial hardships, it shall dismiss the petition or stay the proceedings until arrangements to overcome financial hardships have been made. Further, the court shall not pass a decree for dissolution of marriage on the ground of irretrievable breakdown of marriage until adequate provisions for the maintenance of children have been made, depending on the financial capacity of the parties to the marriage. Further, recommendations made by the Law Commission were that this bar to matrimonial relief shall not apply or come under the scope of Section 23, Clause 1, Subclause A of the Hindu Marriage Act. The government had accepted these recommendations from the Law Commission. However, due to strong opposition, these recommendations lapsed. Now, moving further, let's discuss landmark case laws on the subject matter. In the case of Neetaben Dinesh Patel versus Dinesh Dayabhai Patel, 2021, the husband, who was a respondent, had filed for divorce under Section 13 of Hindu Marriage Act on the grounds of cruelty, whereas the appellant wife filed a counterclaim stating that she and her son were deserted by the husband and were not paid enough maintenance. The husband is cohabiting with another woman and has married her. Hence, the wife has argued that the marriage between her husband and the woman is illegal and void, and the son born through the marriage is illegitimate. The Supreme Court observed that such relief cannot be granted under Section 23A of the Hindu Marriage Act. By way of counterclaim, only those reliefs mentioned under Section 9 to 13 of the Hindu Marriage Act can be granted. Further, in Shrimati Leela versus Dr. Rao Anand Singh, 1963, the respondent husband had already married Shrimati Rupavati Devi before his marriage with the appellant Shrimati Leela. The appellant was a Christian man. The marriage was not solemnized according to the Christian tradition. So the appellant had to convert to Hinduism. A petition was filed by the appellant on the grounds that the respondent had concealed the fact of his first marriage, treated her with cruelty, and had withdrawn from her society. The respondent accepted the fact of his marriage but denied the other allegations. The issues before the courts were whether the respondent concealed the fact about his first marriage, whether the appellant was treated with cruelty, whether there was unreasonable delay under Section 23B of the Hindu Marriage Act. The contention of the respondent was that the petition was filed very late and there is an unnecessary delay under Section 23(1)(d) of the Hindu Marriage Act. The court observed that delay on the part of the appellant is not improper and cannot be rejected. Dear fellows, let's talk about bars to matrimonial reliefs under Muslim law. Bars to matrimonial reliefs are not mentioned under the Muslim personal law, and as such there are no provisions regarding the same. However, the Indian Divorce Act 1869 and the Parsi Marriage and Divorce Act 1936, which govern the provisions of marriage among Christians and Parsis respectively, do mention certain bars to matrimonial reliefs. Now let's discuss these. First is the Indian Divorce Act 1869. This act was the first enactment that introduced bars to matrimonial relief in India. This is the only law in India that regulates divorce among Christians. The bars under the Act are: Section 12 of the Act states that the court, upon receiving the petition for dissolution of marriage, shall examine whether the petitioner has been an accessory to any act or in connivance or has condoned the act or is going through the said marriage or has committed adultery. The court shall also look into any counterclaims, if any, made against the petitioner. Section 14 states that the court, on finding that the petitioner doesn't fulfill the requirements of any of the bars mentioned above, can pass a decree to dissolve the marriage. However, the court shall not pass the decree if the petitioner has been guilty of adultery, cruelty, desertion, or has committed unreasonable delay in filing the petition. Dear fellows, let's discuss the provisions of the Parsi Marriage and Divorce Act 1936. This act governs marriage and divorce among the Parsis in India. A Parsi marriage is considered a contract that will be valid through the Ashirwad ceremony. Section 35 of the Act mentions the bars to the matrimonial relief. If a suit is filed under Section 30, 31, 32, 32A and 34 that talks about the matrimonial remedies, and the court is satisfied that any of the bars mentioned below are not fulfilled, then the court shall pass a decree granting matrimonial relief. These bars are annulment, condonation, collusion, connivance, reasonable delay, and any other legal ground. Next is the Special Marriage Act 1954. Section 34 of the Special Marriage Act 1954 lays down certain bars that must be crossed in order to get matrimonial relief. As discussed earlier, these bars are based on the doctrine of equity, which states that one who comes to equity must come with clean hands. Section 34 imposes a duty on the court to grant relief to the aggrieved party after examining the bars mentioned under the section. It is worth noting that the provisions mentioned under the Hindu Marriage Act and the Special Marriage Act are quite similar. While the Hindu Marriage Act is applicable only to the persons covered within the definition of Hindu, the Special Marriage Act is applicable to all the citizens in country, irrespective of their caste, religion, ethnicity, etc. Further, marriage under the Hindu Marriage Act is solemnized by ancient Hindu traditions and rituals, whereas specific rituals or traditions are not required for solemnizing marriage under the Special Marriage Act. Hence, although similar, there are minute differences between these two enactments. In the case of K. Ramaswamy versus Esther Johnny, 1988, the spouses had married according to the Special Marriage Act 1954. As the appellant Ramaswamy was a Hindu and respondent Esther Johnny was a Christian, the appellant alleged that the marriage was not valid because he was coerced into it by the respondent's family members. He further alleged that during the time of marriage, the respondent was under 18 years, so the marriage should be declared void, and he claimed relief under the Special Marriage Act. The respondent denied all the allegations. The district court judge observed that the appellant cannot claim relief under this act because there was an unnecessary delay in the filing of the petition. The case went to the Madras High Court, which observed that the appellant had delayed the filing of the petition by more than 2 years. So there had been an unnecessary delay on his part. My dear learners, on the basis of the foregoing discussion, it may be concluded that various matrimonial reliefs are provided under personal laws as well as the Special Marriage Act. There are a number of bars to the grant of these reliefs. If the bars to matrimonial reliefs are present in a petition relating to a matrimonial relief, the relief will not be granted. Further, if the decree granting matrimonial relief has been passed, it will be quashed. All these bars mentioned above are absolute under all Indian personal laws as well as Special Marriage Act. Earlier, these bars were applicable for seeking relief only for the dissolution of marriage. However, presently, the scope has been extended to all matrimonial remedies. The only motive for imposing these bars is that the spouse who seeks relief must have a genuine reason and should not have a selfish interest. Hence, the burden of proving not just the respondent's guilt but also his or her innocence is on the party seeking relief. With this, we come to the end of today's lecture. Thank you very much.